Welcome to Lexplosion's continuing series of webinars. Today we will be discussing upon the impact of recent amendments to the Legal Metrology Packaged Commodity Amendment Rules 2022 and the Food Safety and Standards Labeling and Display Regulations 2020. We will be joined by our esteemed panelists, Mr. GLN Murthy from ID Fresh Foods and Ms. Shalini Sinha from Hindustan Unilever Limited, who will help us in understanding how the industry is gearing up and what is the overall impact these regulations will be having over the FMCG and food industry. Our webinar will begin shortly. In the meanwhile, we would like to take this opportunity to introduce ourselves. Lexplosion Solutions is a leading legal tech company providing comprehensive legal risk management solutions. Backed by a team of lawyers, company secretaries, chartered accountants, and IT professionals from leading institutions. Lexplosion's vision is to make legal requirement inclusive and to enable in-house legal teams to focus on their core activities with minimum difficulties and maximum results. We provide a range of legal risk management solutions like compliance, contracts, litigation, extended enterprise compliance, statutory audits, legal trainings, and other services to mitigate legal risks. While we begin our webinar from 3 p.m. sharp, we would like to present a glimpse of few of our solutions through short videos. In case you want to contact us for any of the solutions, email us at enquiries@lexplosion.in.
As your business grows, so do your legal risks. Risks relating to your regulatory compliance, customer contracts, ongoing litigations, and so much more. With almost every employee potentially contributing to these risks, trying to control them using manual checklists and isolated measures leads to inevitable failures. Enter Lexplosion, a pioneering legal tech company providing solutions to mitigate diverse legal problems across leading enterprises since 2007. From its inception, Lexplosion has adopted a client-first approach while marrying its expertise in the legal domain with the latest disruptive technologies. Backed by a team of legal, finance, and technology experts, Lexplosion's vision is to keep simplifying legal challenges with the use of technology so that in-house teams can focus on their core. Lexplosion has offices in Mumbai, Delhi, Kolkata, and Bangalore, and has alliances across the world.
One of the first challenges that Lexplosion mitigated was regulatory compliance management through its compliance suite of ComRisk, Compliant, and Complify. Between the three, your compliance worries are so well taken care of that you can start thinking of the big picture once again.
When you're sitting out there, looking at the big picture, calling all the shots, it's not difficult to overlook the little details waiting to blow up on you. Take this innocent phone call on a late Friday afternoon. This could be your compliance officer with the news that some key contract workers have gone on strike. This could also be your consultant informing you of a show cause notice under a law that you didn't even know existed. There goes your weekend, potentially your reputation, or even your company's long-term existence. All because you aren't ComRisked yet. ComRisk simplifies the whole business of compliance by streamlining the processes in 4 clear steps. Tracking and updating compliances on a real-time basis. Setting up internal compliance processes by understanding how your business actually runs. Monitoring compliance execution through alerts and reminders. And reporting status and progress of key compliance matrices to the board using sliced and diced dashboards. ComRisk does not just protect your company's brand, it protects your weekends as well.
Not every large organization is ready for implementing a compliance solution though. Many need to first get an audit done to know where they currently stand, and Lexplosion has a solution for that too.
Your week begins with an email from the boss. Can I get a report on whether all our on-site vendors are complying with applicable laws by the end of this week? She asks. No, you think aloud before responding with a curt, "Sure, boss." There are a dozen offices and over 100 vendors, and you don't even know where to start. Welcome to Complied, Lexplosion's real-time audit management solution, and your best friend for the week. With Complied, you can commission an audit in minutes, control the pace and cost, delegate parts to different people in the company, view the status and progress of the audits in real time. Be sure that you are auditing for the latest applicable laws and compliances. Get granular assessment of non-compliances and corrective action plans, and obtain a comprehensive report in minutes. You can also add your own questions and use the tool for due diligence. Now that you have all the work set for this week and will have complied on time, maybe it's time for that celebratory meal on Friday evening. Have fun!
Both ComRisk and Complied are engaged solutions for enterprises with refined tastes, structured teams, and a reasonable budget. But what if you are a SME struggling with day-to-day operational and resource challenges? Lexplosion has a solution for you too.
A small Indian business, an office, a factory, a couple of sales offices. To compete globally, you need to be compliant. Obtain registrations, get consents, do ongoing filings. But with well over 500 compliances every year, the job at hand is difficult. Trying to keep pace with changing compliances can eat into your precious management time and be very expensive. But not complying can mean loss of business opportunities with larger companies, significant reduction in profits because of hefty penalties, reputational loss, and even jail. To avoid this, Lexplosion has launched Complify, a complete game changer whose algorithm predicts what laws and compliances apply to a business with just basic details. So what would earlier have taken hundreds of hours and exorbitant professional fees can now be achieved in just a few minutes for a small monthly subscription. So go conquer the world while we worry about your compliances. We are Lexplosion, the legal innovators.
Now that your compliance house is in order, it is time to focus on managing your endless stream of contracts.
Meet Jyoti, contract executive with a global conglomerate. She is conscientious and brilliant, yet she is struggling to keep pace with the drafting, negotiation, and abstraction work hitting her inbox. And finding an executed agreement is a nightmare. First, searching through hundreds of her folders, and then those of her colleagues from the shared drive. Before she knows, the day is gone. The business folks are mad, as is her boss. Enter Comtract, Lexplosion's contract solution. At the click of a button, you can upload those hundreds of folders containing different categories of contracts, sync them to your obligation trackers, create milestone-driven tasks and alerts, get sliced and diced reports of your rights and duties, and you will never again have an agreement expire without you getting an alert well ahead of time. Suddenly, Jyoti's days are structured, and she is once again able to focus on her contracting skills. Backlogs reduce by over 80% in the first 3 months and almost disappear over time. The business is happy and coming to work is a joy again.
With compliances under control and contracts managed, it is time to focus on your never-ending disputes.
Do you spend sleepless nights worrying about adverse ex-parte orders because your counsel did not appear in court? Are you losing control over innumerable matters pending in different courts and tribunals? Do you worry about your litigation spend going through the roof? We have a solution for you, and it's called Comlit, a dispute management software which provides efficient tracking of cases, dates, forums, and lawyers. It auto-generates list of dates, allows one-click upload of all your existing litigation data, and syncs them with your trackers, apart from providing a wide array of reports ranging from case status to contingent liability to budgeting and billing information. With Comlit, managing litigation has become a lot easier than avoiding them.
And if you thought you have heard it all about Lexplosion, think again. Because we complement our products with high-quality services, ranging from compliance consulting, training on various aspects of law, drafting contracts playbooks, and building contracts and litigation trackers. For more on Lexplosion, do visit our website www.lexplosion.in.
Good afternoon, everyone, and welcome to Lexplosion's continuing series of webinars. Thank you for sparing the time to join us for this session on the impact of recent amendments to the Legal Metrology Packaged Commodity Amendment Rules 2022 and the Food Safety and Standards Labeling and Display Regulation 2020. In this webinar, we will be covering the key changes in the amendments and the impact it has on the food industry. I am Aditya, and I, along with my colleague Amanya, a lawyer in Lexplosion, will be discussing some of the key amendments brought under the Labeling and Display Regulation, as well as the Packaging Rule, which needs to be complied by July this year and October this year, respectively. But the display requirement under the Chapter 3 of the Food Safety and Standards Labeling and Display Regulation 2020 is in force from 1st January this year. Later in this webinar, we will be joined by our esteemed panelists, Mr. GLN Murthy from ID Fresh Foods and Ms. Shalini Sinha from Hindustan Unilever Limited, who will help us in understanding how industries is gearing up and what is the overall impact of these regulations on food industry. Before we move further, we wanted to inform all attendees that this session was recorded slightly ahead of actual time of the presentation to ensure that there are no last-minute technical glitches. However, we will be able to take questions at the end if time permits. As most of you attending today's webinar are aware, the Food Safety and Standards Authority of India, that is the FSSAI, has been continuously bringing in several amendments and regulations for the safety of food in India. All these amendments are having a common goal, that is to enable consumers to make more informed choices. Even the Legal Metrology Packaged Commodity Amendment Rules aims to bring the consumers by making the manufacturers, packers, importers disclose additional information, but it has casted increased obligation upon the manufacturers of food businesses as well as upon the manufacturers of pre-packed commodities. So before getting into the discussion on the key amendments brought under these regulations, here's a quick refresher on few important definitions. The Food Safety and Standards Labeling and Display Regulation 2020 applies to all food business operators in India. Food business operator is a person who has a public or a private undertaking who carries out an activity related to storage, manufacture, process, package, transport, or distribution of food in relation to food service, sale of food, or its ingredients. While the Legal Metrology Packaged Commodity Rules is applicable to all manufacturers of pre-packed commodities. So before we dwell further into key amendments, let us understand the meaning of pre-packed commodities. So commodities which are packed and has predetermined value, which cannot be altered without such package being sold or opened, is a pre-packed commodity. Now, my colleague Amanya will be highlighting few key changes which has been brought under this amendment.
Thanks, Aditya. I would now like to discuss on the key amendments brought under the new labeling and display regulations. All these food manufacturing industries have to ensure that not just the brand name will not be sufficient on these food packets. If you are buying a chips packet which just has a brand name and does not clearly mention what exactly is it in the true nature, that is, it's a potato chips, then it won't suffice. In addition to this, they might add fanciful names as well, but they need to make sure that such food items indicates its true nature in the packet. So food manufacturing industries have to relook their labeling covers and rethink on the name of different food products sold by them in the market. Further, the list of ingredients must include the food additives present in that particular food item. Even the logos of the non-veg food items has to be changed according to these regulations. Food manufacturers now have to revamp their internal processes and make a change in the logo of non-veg food item, which now has to be displayed in a brown triangle within a square with brown outline. I think this has been done to enable people suffering from color blindness to differentiate between the veg and non-veg packs of food items. Consumers do benefit from these regulations once the labeling provisions are implemented.
So, Amanya, in terms of logo, are these regulations covering just the veg, non-veg food items meant for human consumption, or there are certain food items which are not meant for human consumption as well? So, is there any logo requirement, any changes for them in these amendments?
That's a very interesting question, Aditya. Well, the food items which are not meant for human consumptions, like the pet foods or the ghee used for devotional purpose, also has to bear a logo of cross symbol in black color within a square with black outline.
So, this implies that the manufacturers will have to revamp their existing labeling information for these items as well.
Yes, in fact, these regulations are also adding additional compliance towards several food manufacturing industries by directing them to mandatorily display the allergen information on the label. So now, if a particular food item contains certain allergic ingredients, then the name of such allergen has to be displayed on the label. There are a lot of chocolates or even butter manufacturing industries which use peanuts in their food item. Now, through these regulations, they have to mandatorily mention in the labels that such item contains peanuts. Even if a food item contains low gluten, that has to be mentioned in the label.
So, Amanya, under the previous regulations, there were provisions to provide for mandatory warnings if a food item contained low gluten. So, is there any other additions which have been made under these amendments?
Yes, Aditya. The regulation specifically mentions about the ingredients which can be considered as an allergen. It states that food items containing peanuts, milk and milk products, fish and its products, soybeans or gluten have to be separately mentioned under the allergen information on the label of that item. Another key requirement is to mention the expiry date on the label of a food item instead of the best before date. We have often seen in several labels of food items that best before and expiry date are interchangeably used or displayed.
This gives more clarity because best before and the date of expiry are two different concepts. So, best before date implies that the food item may still be safe to consume after such date is crossed, though its quality might have diminished. However, the expiry date implies that the exact date after such food item must not be consumed at all by the consumer. So, these regulations are further bifurcating the format in which such dates have to be mentioned in the food items, depending on their shelf life. So if the food item has a shelf life of less than 3 months, then the expiry date format has to be in DDMMYY format. And if the shelf life is more than 3 months, then the abbreviation of the month, the first three letters has to be mentioned along with the year. So this will indeed give a clear perspective to the consumer about the food items consumed by them. However, it has a lot of implication towards the food industry as their entire system has to be updated for labeling of such food items. And this also includes revamping the processes and controls for their vendors who are helping them in packaging. But best before is still optional for the food manufacturers.
Absolutely, Aditya. It does have an impact over the food manufacturing industries, and in addition to the expiry date, the brand owners, irrespective of whether he's a manufacturer or a packer or bottler, have to mandatorily display their name and complete address. This again creates a liability on the part of food industries to mention it on the labels of the food items manufactured by them. So the requirements of FSSAI logos and numbers to be mentioned in the label of such food item was already there in the erstwhile regulations, and this has been reiterated in the new regulations. Also, the food items which are served in railways or airlines have to bear the information regarding the date as well as time of manufacturing of such food item along with allergen information.
Thank you, Manya. These are important pointers from a labeling requirement. And in addition to this, the food manufacturers now also have to calculate the percentage of per serving contribution, a particular food item to recommended dietary allowance of energy, fat, sugar, and salt and display it on their label. They also have to display several nutritional information on their label. This again impacts the food manufacturers. They will have to disclose all information with respect to their food product, and the consumers can take informed decisions while buying a particular food product.
So, Aditya, when you say the nutritional information has to be provided on the label of food item, does that mean that every food items like the curry powders or the alcoholic beverages, all these has to bear these nutritional information?
So, Anya, it's an interesting question, and this brings us to the exceptions mentioned under the amendment, where several food items which have been exempted from the labeling of such nutritional information on their labels. So, food industries which are involved in manufacturing of alcoholic beverage, curry powder, coffee extracts, tea, unprocessed food with one ingredient are exempted to provide for such information.
Thanks, Aditya. In fact, these regulations also precisely states that information like FSSAI license, number and logo, name of the food, the lot number, the net quantities, all these needs to be displayed on the label of non-retail container. So there is a separate chapter under these regulations which have been implemented in the month of January 2022 by the food service establishment. So any such establishment which operates in multiple states or have outlets in 10 or more locations are required to mention the calorific value against every food item which is displayed in their menu cards or boards with a statement on how much energy an average adult requires per day. However, some respite has been given to the hotels and restaurants from display requirement which has been enforced from 1st Jan, that is till 30th June. There will not be any inspection and sampling by the authorities in these food service establishments.
So, Amanya, this brings me to an interesting question. The new amendment talks about food service establishments, but it has not defined it in the law. So, it casts a compliance obligation on food service establishments to display the calorific value of the food item, allergen information, veg, non-veg logo. So, we understand that this may apply to hotels and restaurants, including quick service restaurants. Will this also have an impact on the canteens? And because many organizations, factories, offices have these canteens where food is prepared or served.
Thanks for putting up this question, Aditya. Though the food service establishment has not been defined, it is just the threshold which has been mentioned that if the establishment has a central license or outlets at 10 or more locations, then the food service establishment has to display the calorific value, the veg or non-veg logos, the allergen information. So it is still a gray area whether it will be applicable to canteens. Lexplosion is seeking more clarification on these lines with the concerned authorities that whether these compliance requirements of providing the allergen information, the veg non-veg logo, display of calorific value are applicable to these canteens. There is also an exception provided in the regulation which states that these provisions are not applicable to even caterers or establishments which operate for less than 60 days in a year. This implies that the catering service will not be liable to display the calorific value of the food items prepared by them. But these exceptions does not mention that the canteens of office or factories are under these exceptions. So hence it's a very gray area.
Thank you, Munya, for pointing out the gray area, and it will be interesting to have more details on this. Now, I would like to discuss on the responsibility of e-commerce entities with respect to these labeling regulations. So the e-commerce entities need to ensure that the new labels in the food item fulfills the requirements laid down under the new regulation and are displayed in their portal. Moreover, the e-commerce food business operators have already implemented the requirement of mentioning the calorific value of each such food items sold by them through a food service establishment. These regulations have indeed made the food industry restructure their internal checks and balances. Overall, these regulations are indeed enabling consumers to make informed choices, but casting a lot of responsibility towards the food manufacturing industry. So, from a penalty perspective, though there has not been any change in terms of penalty, it remains 3 lakh for the first offense and can lead to cancellation of license if repeated, along with doubled fine plus a daily fine of 1 lakh rupees. In addition to these requirements, there are a lot of talks going on with respect to front pack labeling to health star rating in India recently. And also in newspaper, there are talks about replacing these health star rating with warning signs. So are there any other countries which have already implemented some or the other structure in the front pack? And what is the update on India? So when are these getting implemented?
Yes, Aditya, there is a 2021 Global Food Research Program by University of North Carolina, which gives us insights on the same. Countries like Thailand, Sri Lanka, Mexico, Brazil do have mandatory label embossing in the front pack of the food items, which helps consumers in making informed choices. In India, the FSSAI is planning to introduce the Health Star Rating System, which is a labeling system that grades packaged food on the scale of 1 to 5 stars, where healthy food gets the maximum stars. There are a lot of discussion going on against it as well, where many health experts are requesting to have warning labels on the packet instead of health star rating, as this might have negative impact over the consumers. These discussions give us the understanding that once these rules are framed, the internal processes of the food manufacturing industries might require some change.
Thanks, Amanya. That was rather insightful. And now I would like to take you through another key set of regulations under the Legal Metrology Packaged Commodity Rules 2022. There were several amendments brought under the Legal Metrology Packaged Commodity Rules 2021, which were supposed to be complied within April 2022. However, there was an extension of the deadline under the Packaged Commodity Rules 2022, and now the manufacturers of pre-packed commodity needs to comply with the same within October this year. Before we delve deeper into the key amendments brought under these regulations, I would like to explain the concept of pre-packed commodities. So commodities which are packed and has a predetermined value which cannot be altered without such package being sold or opened is a pre-packed commodity. The standard packing used for packing such commodities under Rule 5 has been done away with under these rules. This implies that the compliance burden of many industries to pack certain commodities as per the prescribed rules have been done away with.
So, Aditya, let's take an example of a biscuit. Biscuits were packed within a minimum size of 25 grams in accordance with the provision laid out in the Rule 5. So now the biscuit manufacturers has the option to choose the quantity in which they want to pack their biscuits.
So yes, Amanya, and it's not just biscuit, but a lot of products can now be packed in accordance with the manufacturer's wish. Industries manufacturing oils, detergents, ghee, coffee, water, paints, they all have the choice to now pack a particular commodity as per their standards. This indeed gives the manufacturer a chance to conduct market survey and understand the consumer requirement and pack their products accordingly. Apart from this, another key amendment brought under these rules are the earlier the quantities of product on the package could be denoted as N, denoting the number, or U, denoting the unit. But now the manufacturers have the option to express these quantities in terms of pairs, piece, or in any other simplified manner.
Thanks for the detailed explanation on these, Aditya. Further, I would like to add that in the erstwhile rules, the month and year in which the product was manufactured or prepacked or imported, anything could have been declared. But the present amendment to these rules require the declaration of just the date and year of manufacturing. therefore removing lot of confusions and ambiguity which was there earlier among the importers of pre-packed commodities. Another significant requirement is that now the manufacturers will now have to make these additional declarations to MRP by mentioning the price of commodity per unit, per kg, per liter for items weighing more than kg and liter, or per gram, per ml for items less than kg and liter. So this will increase the compliance burden of manufacturers who now have to relook into their packaging systems. But it will definitely help the consumers in distinguishing between various commodities. For instance, if there are two brands selling edible oils at a particular cost for 5 liters and 6 liters respectively, these edible oil packets has to contain the information about what is the cost per liter. So now it will become easier for consumers to understand which brand they want to go for.
Yes, Amanya. And these rules does have an impact on the manufacturers, packers, importers, where they will have to revamp their internal processes. And while it gives the consumer more freedom on the choice they want to make in terms of what they are consuming, along with more disclosure from the manufacturers, packers, and importers. Now, moving on, now let's discuss in detail the impact which it will have upon various stakeholders. The e-commerce industries will have an obligation to display the calorific value, maintain the labeling information in their website, and overall have a visibility that all correct information is updated in their portal. Recently, what I have observed is that these e-commerce entities selling food items do provide for a clause below a particular food item which states that reasonable care is taken to provide for correct information about the food item. But at times, the manufacturers may alter their ingredient, and hence it is recommended to not solely rely on information but read the labels before using such food products. So here the responsibility is on the e-commerce, wherein they are providing the disclosing the details, and also the food manufacturers, the packers, they are also providing the details in their labels.
Yes, Aditya, apart from e-commerce, it is the food business operators or manufacturers who really have to bring lot of checks and balances and change in their labeling process. If these manufacturers have non-veg food items, then the entire logo has to be changed for such food items. Moreover, the food business operators have to check if their food items contain certain ingredients which are allergic to humans. Now, the date of expiry also has to be mentioned, which means that the manufacturers have to now decide what exact date can be mentioned for the same. These regulations will majorly impact the food business operators as they have to re-strategize their internal processes within the set deadline, that is 1st July 2022.
Agreed. And a lot of these changes will have a direct impact upon the food business operators. Now, if we see it from the perspective of manufacturers of pre-packed commodities, even they need to revamp and bring change in their internal processes of packing, labeling, as they now have to display the certain information and also calculate unit sale price and mention it on their packet. But omission of Rule 5 gives the manufacturers a flexibility in packing the commodities as per their choice. This also opens up the possibility of conducting market survey among the consumers and pack commodities in accordance with consumer choice or requirement.
Yes, Aditya, manufacturers will now have the flexibility to decide on the size of packaging for particular commodity by conducting market survey. But one thing which is very evident is that this regulation is having a very positive impact over the consumers. A detailed labeling of food items as well as mentioning of unit sale price on the pre-packed commodities gives the consumer the control to switch to healthy choices and make informed decisions.
Yes, Amanya. Consumers will benefit through these regulations, but this leads us to the question where it will be great to understand how well are food industries prepared for these changes and what is the impact of these changes. To understand this better, I would like to introduce our panelist for today, Ms. Shalini Sinha, General Manager Legal of Hindustan Unilever Limited. She has rich experience as an in-house counsel across industries, which include Steel Authority of India Limited, Tata Motors, and with HUL for the last 7 years. At HUL, she is the legal lead for the food business that includes legacy brands like Horlicks, Kisan, Red Label, Quality Walls, and Brew, to name a few. And we also have Mr. GLN Murthy, who is the Chief Manufacturing Officer of ID Fresh Foods India Private Limited. Mr. Murthy has over 2 decades of experience in the food and dairy industry and has been associated with organizations like Britannia, Mother Dairy, Leher Foods, PepsiCo, and MTR Foods. Please join us in welcoming Ms. Shalini and Mr. Murthy for their valuable inputs to today's discussion. So, Mr. Murthy, if I may start by asking you, will these new regulations lead to companies change their product formulation and manufacturing processes?
Not really. As far as food manufacturing is concerned, it's always well gowned, and whenever the new products are launched or whenever the new products are designed, it takes into account the legal and the regulatory requirements of the law of the land, which is prevailing. So such changes is basically an upgradation which is consumer centric in terms of how the consumer need to have, what kind of information the consumer need to have before they choose the product. Whatever regulations, if you see, be it the allergen declarations or be it the price per gram or be it any other declaration. So it's never that it asks for any change in the process per se. And FSSAI has a very clear guidelines in terms of the categories which are well defined, and further there are the categories which fall under the proprietary food. So before we get into listing any of these products, so it's well thought through and the process is well defined. So it really doesn't ask for any change in the process per se. Yes, when we look into the compliances to all the new changes, I don't say that it has any concerns or issues, but definitely there are certain challenges with respect to the timelines which each industry will have their own challenges to meet out their timelines. That is where it is. Otherwise, I don't see any issue with respect to the design protocol for the product per se.
Sure, thank you. Shalini, do you want to add something to this?
So I think pretty well captured by Mr. Murthy. So what has really changed is the labeling regulation, and not how the products will be formulated, and hence any FPO when at the stage of formulation, that has always been regulated. The change really is how much you put on the label, and where do you put it on the label, what's the manner in which you label it. So no, I agree with Mr. Murthy fully that this is not going to lead to any significant change in formulation of the products. Most of the large and compliant organizations have adhered to the FSSA regulations and their own internal guidelines and what they think is right for the consumers. And hence, for such organizations, there wouldn't be any significant shift.
So, Mr. Murthy, you mentioned that there might be some challenges with respect to the timelines. So will the companies be able to exhaust their existing packaging and help businesses realign themselves with the new regulatory requirement?
See, that's exactly. So basically there are two front challenges. So one is some bit of upgradation on the facilities or the things what would be required. For example, in case of allergen management, you definitely need a different level of upgradation to manage the allergen per se. But the second biggest challenge is basically the packaging material stock. And it's always there that for any of the industry, if you take 20% of the SKUs actually contributes to 80 to 90% of the business. So the balance SKUs, actually it's a tail SKU where around more than 60-70% of the SKUs which contribute to the lesser business. And that tail is one thing which the inventory management for that particular tail becomes a bigger issue. And hence, whenever such changes do happen, the first thing that comes in is how much do I waste when I actually get into this kind of compliances. So that is the balance between the compliances versus the waste management when it really, where it really hurts the FPO. And actually the easiest way to actually deal with such kind of scenarios now we have some changes. In fact, if you actually look into the changes over the last year, there's been around 15 to 16 changes that each FPO had to comply with, and that was a lot for the industry to comply with. But now, if in 2022, if these changes are met, then I would say that we should have a periodic way of dealing with it. Like, let's say if 2022 is what we have done all these changes, can we look at second set of change coming in somewhere in 2025? So there is a 3-year period, and there's a lot of time for the draft notification, for the to and fro discussions around it. And then the industries are better prepared, both from the inventory management perspective and also from the upgradation perspective. And it is there on top of the mind that yes, on 25, I will be getting some changes to work around, which is again consumer centric. So the industry is better prepared for it, is what I feel.
Sure. Thank you. And Shalini, so what best practices have you adopted for smooth adoption of these new regulations, and which can help our audience to understand? We know it's coming on 1st July 2022. So is the timeline sufficient, or what practices have you guys adopted?
So, Aditya, there are actually two questions in one question. One is on the timeline on which Mr. Murthy is given his viewpoints, and I largely concur with that. And we've been given a huge reprieve by the FSSA, with this extension that came in, allowing compliance by 1st of January. 1st of July. Was 1st of January. Yeah. So, considering, so I think FSSAI has been pretty considerate, and, they've taken into account that the second wave hit the organizations in the midst of, the entire 1 year period that had been given. And then, although the notification, came into effect from, was notified on 17th of November 2020, the industry, was continuing to engage with FSSAI on certain things, including font size and other things. And hence, when did people really get into action? That would have been in the middle of, March, April. That is when the organizations got into action after, getting all the clarity that they needed for their respective businesses. And even though this whole, labeling regulation has been in the discussion for a pretty long time now, from the time the draft came to the time when it has been put into effect now. Yes. But the extension really came at the end, at the fag end is how I would say, just a month before the due date was there. So I think the extension has been very helpful, and how it's also helped the organization is that most organizations, kind of went with the thought that my deadline is, November 2021, and hence the extension coming at the last moment, it was a reprieve, but then there was already a large, amount of processes and deliberation that the organizations had already done, and and what we typically do at HUL, and I don't know if I can call it best practice, but then I think it's a part of the culture that we really, as far as compliance is concerned, honestly, we take a very conservative approach here, and I believe that most large and compliant organizations do take a similar approach. So I think one of the best practice, if I may call out, is really being conservative and not being very adventurous about legal requirements, and that's really a long-term termish thing. It's not something which is triggered by one regulation or the other. The other thing is that again, which is long-term and which cannot be done over a short period of time, is we're pretty tech-enabled. Yeah, so a lot of our systems and processes have technology driving them, and this kind of reduces the chances of any manual error that may creep in. And of course, once the notification came in, because you really start working on the compliance only after the notification comes. You cannot jump into it at the time when the draft is there.
Yes.
Especially because, Mr. Murthy referred to the complexity related to SKU inventories and all that. So I think what we've done is really, put up a core team on cross-functional planning, and given the kind of changes that are required, it means R&D and planning and legal and manufacturing, everybody. So there've been cross-functional core teams that have been working on it with constant cascades after cascades by the relevant teams to the relevant teams, and closer in time. Now we're just about 60 days away. Now there's a weekly tracker which runs within the organization, and please try to appreciate that it's a huge organization with a very, very different kind of businesses within the foods vertical. Also, we have so it's not that we just retail, we sell on e-com also, of course, not directly. Then we have a we have a UFS business, and we call it Unilever Food Solution, which caters to HoReCa. So pretty diverse in nature. But because of this complexity, we have a weekly tracker, which is initiated by the legal team and which is circulated to the business leaders of the different verticals of the food businesses to check how the progress is week on week. And the right person then keeps a tab on how their businesses are doing. And as Mr. Murthy also said, that there are two sides of the coin. One is, will I be able to land a compliant pack by 1st of July? That's one thing. The other is, what do I do if I have OPMs? Yeah. So the pack mats need to be exhausted, and while the first will be in your hand, the second may not be in your hand, unless your inventory cycle is really that flexible and that perfect. So while the first is the easier one to handle, usage and writing of old pack mats, I think most companies will face this issue, and that's where discipline is going to help. I think closer in time, this will be an issue. Writing off of pack mats will be an issue that most people will be faced with, and we don't have any plans of being of any wastage. We're trying to minimize the wastage, zero wastage or net wastage. That's how we are working on it. One is be compliant by 1st of July, and the other is minimize the wastage.
Sure. So some of the best practices which we can take here is try to minimize as much as possible about the wastage, and to have at least a weekly tracker or a periodic tracker to track these changes. Thank you. That gives us a lot of insight on the practical aspect of it. So Mr. Murthy, this is more from a vendor management perspective, which helps a lot of organization in packaging, manufacturing. So will these new regulations impact those small and medium business operations? Will they be able to revamp their model of business without much turbulence, just like other larger organizations?
Yeah, so basically what happens is, even when we look into the vendor management per se, most important aspect is whenever such kind of changes come into effect, and I think we should start preparing early when we have this draft notification per se, and it's always there. Like I have not seen that any draft notification drastically getting changed in the final thing. So it is, the only thing is probably it would get delayed to a certain extent of time, but otherwise it's bound to come in. So hence during the draft stage itself, probably that's where we can be actually proactive to help all the key stakeholders around the business to actually get aligned to that, and the transition could be much smoother when we see this. And one such example is actually, if you look into the allergen declaration, though it's just now getting firmed up, but this has been on the talks for over the last 2 years, and there are many companies where they had in fact actually gone ahead and implemented it before it had become a law. So that kind of examples are there. So basically, one has to be proactive so that all the key stakeholders are involved in it, and at the same time the important aspect is we don't have any wastages to manage with. Is what I feel.
Sure. So, like you mentioned that, yeah, yes, Shalini, please.
Be after you.
Yeah.
Please, Shalini, you can.
I was just adding that typically the way we see we see the draft notifications within the organization is that we try and assess that if the final notification were to come exactly in the way the draft is to be, then how ready I am, and how much of time we analyze the gap. What is the gap that we'll have to cover for, and how much time will it take? How much what is the kind of planning that we need? How much of is there any money that that is required to be pumped in? So we keep that analysis ready. Still wait for the final draft, but we presume that the final will be what the draft is. So that helps us in readiness.
Sure. So like you mentioned, proactively, a lot of organizations start implementing these changes at the draft stage. So this brings us to the next question, as in how can legal tech companies like us minimize the burden around the compliances, since it's ever changing? Mr. Moti mentioned there have been 15 to 16 changes in the last 2 years with respect to FSSAI. So how does legal tech companies may help you in minimizing those risks?
It's to me.
Yes, Mr. Moti, you can.
Yeah. So if I talk about Ms. Halini's company, it's a larger organization with many people around. The whole team can actually manage the compliance front. But actually, the legal tech would actually be more important it'll be more important for the smaller setup, wherein the structure would not have evolved a lot. And it's an information which will actually help them to act upon. Otherwise, in the smaller organization, there's always chances for the information to be missed across. So the legal tech firm like yours can be a good partner to them to periodically feed in the critical information that is required, the critical changes that is required, so that they are well prepared on this front. I think that is where the role is magnified there.
Sure. Thank you, Mr. Moti. And Shalini, and how do you feel legal tech companies can help around these changes which are happening so fast?
See, if I look at it from a large organization lens, I think that I wouldn't shy away from saying that legal tech specifically is essential today. Yeah, it's no more a preferred option or no more a choice, because again, because of the largeness, in size, the complexity, the kind of matrix that makes this organization in the entire back-end work that keeps happening. I think it's something which is really essential because, law doesn't see how big, how small, what's your origin, anything like that. Law just requires you to be compliant. And for a large organization, this cannot be done by people like us. It has to be automated to the extent possible, and that's where the role of legal tech comes. And it significantly reduces the burden of compliance. Yeah, for a listed company like ours, it's a compliance reporting that happens to the board every quarter and quarter. Yeah, so anything that gets missed is actually something which becomes a governance risk apart from a legal risk or any other risk. And that's really where the role of legal tech comes. And I think it's not just tech, and now I would want to differentiate between tech and legal tech, yeah, because technology can, definitely run on its own, it's a set of algo and you put it. But what goes into that algo is really important, and hence, that's why legal tech, because you need people who understand things, yeah, who understand what are these changes, and that's why the system, the way the system is designed, has to have a legal brain behind it. Yeah, it's not just simple coding that happens. It's a combination of expertise in coding as well as law. And I would believe that legal tech is an important part of
Absolutely. Thank you. Thank you, Shalini and Mr. Murthy, for giving us insights from a legal and from a manufacturing operational perspective. I'm sure our attendees have found this useful. Now we move on to the live session, and we have received few queries from our guests and attendees. We have received some questions here. One of the question is how to sell engine components in stock which has old MRP, as the engine part are not sold on weight dimensions basis. So, Shalini, if you would like to answer this question.
Yeah, absolutely. Answer that question. It's a little, different from the industry that we're talking about, largely the food industry. But the LM regulations would still apply. Yeah, and the packs have to be compliant. All of your packs have to be compliant with the legal metrology regulations. And I see that there are a couple of questions on this whole engine thing, and I just want to take maybe all of them together if you are
Absolutely.
okay.
Absolutely.
Yeah. So a couple of questions that I see are date of manufacturing. No, sorry, I just went through these questions. Okay, so no, I can't get them now.
I can. If you want, I can just. Is the date of manufacturing mandatory for all products? Is it applicable for spare parts? So far, they follow date of packing.
So essentially, understood. Yeah, I recall them now. So yeah, essentially, the legal metrology, what you'll have to do is really, look up the legal metrology act and, see what are the ones that are applicable to you. And there are certain exemptions that the legal metrology act provides, and, whether your packs are the ones that are exempted. What I recall from, since I've worked with Tata Motors and also, partnered the spare parts division, it's a huge division in Tata Motors from the servicing angle. All of these regulate the LM regulations are definitely required to be put on the pack, but depending on what is the nature of the pack, whether it's a bulk pack, whether it's a retail pack, whether it's a consumer facing pack, the requirements of what goes on your label will change. So, my suggestion would be, really look up what the requirements are for the kind of business that you're doing. There wouldn't be one straight answer on what goes on which pack.
Absolutely. Thank you, Shalini. So, Mr. Murthy, you talked about the wastage, and since the timeline is 1st of July, many organizations may or may not be able to complete as in replenish all their packages. So, do you think from a plastic waste management there can be some challenges? There are extended producer responsibility. So do you think there will be more challenges on that front?
See, these are two different parts of the plastic waste management rules, and the extended producer responsibility is more inclined towards the environmental laws and guidelines. This has nothing to do with the current notifications or current changes, what we have been discussing on. When I said that the waste is one thing which may come up, suppose if we need to write off a lot of packaging material, so that is the national waste is what I had mentioned. Now, there are various ways to tackle that in terms of how do we actually minimize that? How do we talk to the department and try to get extensions in terms of using those packaging material? As I said earlier, also it is majority of the fast-moving products in any organization would actually be easy to migrate because the packaging material stocks will not be much higher. Whereas in case of the slow moving or the tail SKUs, that is where the exceptions needs to be looked upon. As far as plastic waste management and extended producer responsibility, it is different regulations altogether.
Thank you. That gives a lot of clarity. So another guest had asked a question. Will vitamin filters be covered under FSSAI license? So we know there is a combination of vitamins, minerals, there are single vitamins and minerals, there are various dosage formats. And so there is a FSSAI regulation, nutraceutical regulation, which covers that. So depending upon the dosage format of the tablets, capsules, so that will be covered under FSSAI. I hope that gives the answer to the question. So that was one of our questions. And there was another question which is here with respect to multi-pack and assorted pack. So we understand that now with multi-pack, assorted pack and this FSSAI amendment, you will have to disclose the date of expiry of the product which has the lowest shelf life. So I understand. So Shalini, from a company's perspective, where multi-packs, there are assorted packs, how does this impact? Wherein the date of expiry of the closest product which has the lowest shelf life has to be mentioned. So how does that affect your planning?
Initially there was a lot of confusion on how these multi-piece packs, how these combo packs will be dealt with. But some time back, I think about a fortnight back, the legal metrology department, they've come up with a set of FAQs in which they've tried to answer this question. So again, from let's look at what is the laws, what does this amendment really say? This amendment really doesn't change the law as far as expiry or what goes on the label, all that is concerned. Primarily what changes for the FMCG industry is really primarily on the USP. Yeah. And that is where the focus is. On the other set of information that has historically been going on the packs, there's not much change. However, the question on expiry is still connected to the question of USP, and what they have said is that in a pack, where your USPs are different, yeah, then you will, if your pack has a transparent covering, yeah, where from the outer pack you can actually see the inner pack. Then you put it on the inner pack, you don't necessarily have to put it on the outer pack. And similarly, they have given all of these clarification. As far as the specific question on expiry is concerned, yes, the expiry of both the products will have to be mentioned. And the classic example in our case, would be a toothpaste, a toothbrush kind of a combination for a Pepsodent brand, or a hair conditioner and a hair shampoo kind of a product, hair portfolio. But the expiry of all of the products will have to be made visible to the consumers. But then the point that I'm making is that hasn't anything to do with the changes that have come up. Primarily, the LM changes around the USP and the FSSA changes are around, what are the additional information that will go on the pack. And the way the expiry date will be mentioned, only that format is changed.
Yes. Thank you. So we have another interesting question here. Can a product have different MRP for different states? So Mr. Murthy, Shalini, if you want to take this question.
Yeah, I'll take this. This is again something which is not connected to the recent amendments
yes,
that we spoke of. However, sometime back, again, LM had clarified, what is permissible as far as you could have different packs with different prices. But when you have similar packs, so when you have the same pack, the same set of product formulation, you're selling it across channels all across the country, then the MRP needs to be changed, unless you can really differentiate it on the basis of some reasoning, some logic, whether it's your formulation, whether it's your technology that you're using, whether it's your logistics, something like that. But if the product is exactly the same, then the MRP needs to be the same.
Sure. Thank you so much. So we have a more specific product related question here. So it is more on impact on the edible oil manufacturers. So on that we know, so in this amendment, the packet jars where earlier we used to see the label had super refined, extra refined, double refined. So these exaggerated words, like the law has mentioned here, cannot be used. So now I think the companies will have to mention just refined oil, and additionally there are product-wise, there are various requirements. So this amendment has listed down a lot of products where you need to define and you need to disclose in your label. Example, I think there is Vanaspati also, wherein if you have more than 30% of rice bran, you will have to declare the same. So depending on the product, a lot of labeling requirement will undergo change. So that was one of the questions. Again, somebody has asked, are there any change with respect to area and size of principal display panel of various products with respect to the numerals, so their height of the numerals? So, Mr. Murthy, would you like to take, or? So I know, so I think there is one small change here with respect to height of any numeral or in the declaration. So that is specifically if it's more than, I think, 2,500 square centimeters. So if and then there will be a change in the size of the declaration. So there is just, it seems like a small change, but I'm sure it will have a legal impact and operational impact on products wherein the size is 2,500 square centimeters. So that was one product related questions which was asked. So thank you. This brings us to the end of this webinar. But before that, I would like to ask one small question to our panelists. I know there has been various extensions given. So this is your experience. Do you think this is enough, or you think the authorities might give another round of extension on the timeline by when this needs to be implemented?
I would say difficult to comment at this stage. Even last time when the extension came, it came at the fag end. I am not even sure if this is, actively being sought by the industry. However, as I stated earlier, there will be, PM-related issues, and a very valid point that was raised in one of the questions is that, ultimately it's more of plastic in the environment, and hence, it doesn't make sense, when you see it from a well-rounded approach. And there could be request being made from the industry to the authorities right now, but then they've already given 8 months of time after giving, almost 1 year. So they may be reluctant, but I think if there's a case in point, they have been considerate in the past, and they could look at it. The only thing is that, they may give a very short period now to exhaust the existing PMs.
Thank you, Shalini. So this brings us to the end of this webinar. Firstly, I would like to thank Ms. Shalini and Mr. Murthy for sparing their valuable time and giving us the legal and practical perspective on these amendments. I would like to also thank all our guests and attendees for joining this webinar and making it a success. We understand that due to paucity of time, we could not answer all questions, and we would reach out to you post this webinar. We also understand there are many more changes for different products from a labeling perspective. And we have covered few in this webinar. And like we have seen in our questions, there were product-specific questions which have come up. We have our homegrown state-of-art regulatory compliance management solution, Commodities, which is catering to more than 200 clients currently, and it will help you in managing your compliance requirements. Please reach out to us at inquiries@lexplosion.in for more queries, and we would be happy to assist you. Thank you so much.